Welcome back to Real Estate 101. Today we're going to talk a little bit about immigration law, specifically work permits and permanent residence. And I'm pleased to be joined by Asher Frankel of Devry Smith Frank LLP. Asher, welcome to the show.
Thank you for having me, Joe.
All right, Asher, so what is the difference between a work permit and permanent residence?
A work permit grants an individual temporary status. All work permits will be for a specific period of time. Many work permits will specify a certain employer and a specific occupation so that the individual can only work for that employer in that line of work. There are certain work permits that can be issued on an open basis, but all work permits are temporary in nature. On the other hand, permanent residence is, as its name implies, permanent status. A permanent resident has no time limit as to the duration that the individual may remain in Canada. Basically, a permanent resident has all of the rights of a citizen except to vote, and certain jobs, mainly government positions, require citizenship.
All right, so let's say someone is here on a work permit and they come here and they love being here and they want to stay here. Is this possible?
Yes, very much so. In fact, the government encourages people who have established themselves here by working in Canada on a work permit to apply for permanent residence. There are several strategies which can be employed. I would like to focus on a category known as the Canadian Experience class. This is specifically designed for individuals who have 1 year of work experience in Canada within the 3 years prior to applying. They may be granted permanent residence under certain circumstances, which we'll get into shortly.
All right, so I've heard that you've got to score a certain amount of points based on age and some other factors. How does that work?
Okay, so that is one of the hallmarks which distinguishes the Canadian Experience class from other strategies, other categories of permanent residence application. You're right, there are certain categories which require the individual to meet selection criteria such as age, level of education, etc. The Canadian Experience class is unique in that it's a pass-fail system. If you meet the requirements of the Canadian Experience class, then you're in.
Okay, so what is the criteria that needs to be met in order to request permanent residence here in Canada?
Right, so first of all, there are two criteria which are applicable to all applicants for permanent residence in Canada. Everyone must undergo medical and security clearances. There is a thorough medical exam, and if any medical issues are discovered that could preclude the individual from applying for permanent residence. And likewise, one has to provide police clearances from every country where the individual has lived for more than 6 months after age 16. In addition to those, the unique ones which are relevant to the Canadian Experience class are that one has to undergo a language test in either of or both of Canada's official languages, English or French. The other requirement is that the work experience cannot be any kind of work experience, but it must be at what the criteria describe as a skilled occupation. So it has to be a high to medium skill level. It can't be a lower skill level. And the final requirement to qualify under the program is that the 1 year of work experience is based on full-time work experience. And full-time is defined in the regulations as being a minimum of 30 hours per week.
Okay, so does the 1 year of work experience have to be immediately before filing the application?
That's an excellent question, and the answer is no. The law is very clear that the experience in Canada has to be for a period of 1 year within the 3-year period prior to applying. So for example, if one is an employee of a multinational corporation and worked in Canada a couple of years ago and the employer transferred the individual overseas, that person could still qualify to apply now for permanent residence under this Canadian Experience Class program, provided again that there would be a full 12 months of experience within the past 3 years.
All right, so how is someone to know that the work they're doing is considered skilled in order to qualify?
There is a document which the government relies on. It's known as the acronym is NOC, or the NOC as we call it. It stands for the National Occupational Classification. Basically, the NOC is a dictionary of every conceivable occupation and with a skill level assigned to it. So what a government official would do upon reviewing an application, they would see what is the occupation this individual is applying under, and then determine whether or not it meets the required skill level by reviewing the occupation in the NOC. And incidentally, that's part of the art in filing the application, is whenever we assist someone in filing an application, we make sure to identify the specific NOC, and we point out to the reviewing officer what that skill level is and how it fits into the program.
Okay, so other than figuring out whether or not it's a skilled trade, are there any other areas or details in where someone may seek professional advice?
Very much so. For example, the program precludes self-employment. One of the very popular programs for work permits in existence right now is an open work permit program for graduates of certain post-secondary institutions. So for example, if one has graduated from University of Toronto and that individual is now eligible for a 3-year open work permit. And individuals from foreign countries will look around to find an employer. Very often the employer will structure the relationship with the foreign worker as an independent contractor. Sometimes they do it because they don't want to pay withholding, etc., employment insurance, Canada pension plan payments. Whatever the reason is, they'll structure it as an independent contractor relationship. And I have a case right now where exactly that situation. And if immigration feels that this is self-employment as opposed to an employer-employee relationship, then the individual is precluded from applying under this particular program. In the case that I have before me right now, we're making representations to the government that even though it appears on its face to be an independent contractor, self-employment, the reality is the employer controls whatever it is the employee does, and the employee has no freedom to do whatever he wants, whenever he wants. So in reality, it's an employer-employee relationship, and I think we're going to be successful. So that's one example of an area where professional assistance can come in handy. A couple of other things to know is that certain occupations are precluded from the program. For example, bookkeepers, cooks, and administrative assistants, just to name 3. So you want to know before you go to the expense of filing that your occupation simply doesn't qualify. Another example of where professional assistance can be important is the government has imposed caps. So there is a cap on the total number of applications that can be received under the program on an annual basis. And then within the program itself, there are subcaps for certain occupations. Once again, before filing, one wants to get some professional advice to ensure that they're not filing under an occupation which has been closed and it's going to be rejected.
Okay, so you touched on medical and security clearances. When do these come into play? And can you give us more information on it?
Yeah, I'll give you a very brief description of the process. So first of all, to initiate the process, the individual must complete the language test. You cannot file the application unless part of the documentation is the official result from the language test. Then we would typically accumulate all of the supporting documentation from the employer. Typically we would include a T4 to document at least 1 year of experience,
right,
a reference letter from the employer. The whole application process is very much forms driven. So, and I've had PhDs who look at these forms and say, I can't make top or bottom out of this. How do we fill these out? So we complete the forms, we put the package together, including the language test. It's submitted to immigration. There's a central intake unit. At some point in the process, immigration will review the package, and then if everything looks like it's going to go forward, they will request medicals and police clearances. The whole process takes currently approximately a year to a year and a half until a visa can be issued.
Okay, Asher, so for today's final question, is there anything people can do to start the application process on their own?
Yeah, I recommend that they try to collect as much information as they can. Immigration Canada provides quite a bit of information on its website, which is www.cic.gc.ca. That's the first thing I generally advise someone when they call me. And try to take a look at the forms, see how comfortable you are with completing the forms and accumulating all of the supporting documentation. I will provide an additional caveat that I do receive feedback from a lot of people that the forms are complex, and I will also tell you that immigration takes it very seriously, so that if there are omissions on the form or errors, if all of the supporting documentation is not provided properly, if the support letter from the employer doesn't describe the occupation in terms which will make it clear that it's the appropriate skill level, then it could sit on someone's desk at immigration for 3 to 6 months until finally they'll send the whole package back to you. So if timing is of the essence to an individual, if their work permit is going to be expiring in a year or so in the future, then it's always best to get professional advice. Try it on your own first and then go seek out professional advice.
All right, Asher, I want to thank you for coming on today's show. It was a great topic. You brought a lot of good information, and I hope to see you again sometime in the near future.
Thank you, Joe, for having me.
So if you need any help on immigration law or need the help of an immigration lawyer, get in contact with Asher Frankel of Devry Smith Frank LLP. I'm Joe, thanks for watching, and we'll see you next time.